So I'm going to go ahead and hit record to computer. It is being recorded so that I can send this out later, and we will get started. All right, it looks like I'm sharing my screen already. Perfect. Hello, everybody. My name is TJ Scott, or Timothy Scott. I am an estate planning attorney, and I am the owner of the law office of Timothy J. Scott. And I'm so happy to be here with you today and to be talking with you today. We're going to be talking about something that I know is a difficult topic for a lot of us, but I believe knowledge is power, and that's what I want to give you today. I want to give you knowledge, and I want to empower you around this topic so that you don't have to feel anxious, you don't have to feel worried about it, that you can have clarity and peace of mind about estate planning and about exactly what it is that you need to do in order to get your affairs in order. So I have some really valuable information I'm excited to share with you tonight, and I have some valuable offers that I'll be sharing at the end of the presentation. So I hope that you'll stick with me all the way to the end of the presentation. The best way to learn here tonight is to be present with me. You have chosen to set this time aside to learn about estate planning, and it is a complex topic. And I promise you, we're going to go through it in the most thorough and simple and easy to understand way possible. But it doesn't change the fact that we're talking about the law, and laws can be really complicated. And so I want you to be here with me today. I want you to give yourself this time to learn about estate planning. And I want to encourage you to turn off any distractions. If you have another window open, if you have another tab open or something like that, I encourage you to set it aside for now. We will talk for about an hour, and that whatever that distraction is, whatever that thing is that might draw your attention away from this presentation, I promise it'll still be there in an hour. So I always say your future self is going to be glad that you took this time to learn with me tonight. And again, if you stick around until the end, I have some really valuable offers that I want to make to you and that I want to give to you. And the first offer that I have is a free virtual one-on-one meeting with me where we can talk about the things that you own and the people that you love and exactly how you can take the next step to making sure that those things and those people are protected. Plus, I have a bonus gift that's going to make it even easier to get a personalized and tailored estate plan in place for the people that you love. So let's see here. I can pop up a poll, and I'm going to do that right now. And the question in this poll is, do you have an estate plan? And answering this poll will kind of help me to understand where I should direct my attention tonight. If everybody already has an estate plan in place, that's fantastic. I'll help you understand that estate plan better. If nobody has an estate plan in place, that's okay. We can talk about exactly what estate planning is and what purpose it serves and how you can get started in getting your estate plan. And it looks like most people are saying that no, they don't have an estate plan in place. In fact, I haven't seen anyone actually say that they have an estate plan in place, but maybe that's just because they already have an estate plan in place. They don't feel the need to participate. Oh, I do see somebody said, yes, they do have an estate plan in place. So we're going to talk from both perspectives tonight. We're going to talk about if you already have an estate plan in place, great. What does it say? Do you understand it? Is it legible? Did the attorney who helped prepare it for you bring you along in the process and make sure that it was your plan that they were writing, that they were really writing it for you, or did they kind of leave you behind? If you don't have a plan in place, you're not alone. And in fact, let's go and talk about that right now. You're certainly not alone. In fact, something like 69% of Americans do not have an estate plan in place. And if that's true for you, why? Maybe you feel like you're too busy. Maybe you feel like you are too young. And I'm going to post a poll here. Let me know if something like this resonates with you. And, too busy, I certainly understand it. As a father of 3 young kids and somebody running their own business and a lawyer helping a lot of people, I know exactly how busy life can be. But if that's the case, I want to commend you for being here with me tonight and taking this time to educate yourself about this important topic and get an estate plan in place. And I see somebody saying, have a plan now, but I am looking at divorce. Yep. And so I will need to start over once I figure out where I am financially. Absolutely. That is very important. making sure that you have an estate plan in place after a divorce is really important, because the ex, if you have kids and the ex is the parent of those kids, they are kind of a natural person to take over the finances if something should happen to you, and those monies are being used for the kids. And I know that's oftentimes not what you want when you've gone through a divorce. You don't want that ex-spouse being the person responsible for the finances for the kids. So glad that you shared that with me, and I hope that you'll share if you have other questions later tonight. Maybe you feel like you're too young, and I do see some people saying too busy, too young, too expensive. Even as far as too young, anyone over the age of 18 should really have some foundational estate planning documents in place. It is really important that you get certain things in place in case you become incapacitated, or on the very off chance that you die at a young age. You really want to have things be simple for your family. And we'll talk about that tonight, and we'll talk about some of the things that I think are especially important to have in place. But I can tell you, I have helped people who never expected to have a loss at a young age. And I have helped, for example, a wife and some young minor daughters to get through the process. And it was a messy process because things hadn't been put in order. But it doesn't have to be that way. You can get some foundational documents in place, and you can do it affordably. And I'm going to tell you how you can do that tonight. Too expensive. Before word processing, estate planning really was way too expensive. It really was just for the wealthy. But today we have word processors, Microsoft Word. Estate planning is really for everybody. Everybody can get an estate plan written and take care of things for their family. And I'm going to have bonuses at the end, again, just make it even more affordable to get a plan in place. And maybe you're worried about jinxing yourself. I don't see anyone saying that they're worried about jinxing themselves, but I have seen it in the past. And I can tell you, I have written a lot of estate plans, and I have never seen a correlation between somebody writing an estate plan and having something bad happen to them. I see in chat, don't know what all needs to be included in an estate plan. I completely understand that. And that's something that we will be talking about in depth tonight. A lot of people, when they hear estate planning, they think will, and a will is a part of an estate plan. But really with an estate plan, you want to plan for incapacity, and you want to plan for after you pass. And the way that you're planning for incapacity and after you pass are really important too. And so there are some different tools and some different instruments that we look at, as well as a more rounded, complete estate plan should include a lot more than just documents. And working with a counselor who understands that is really vital in order to get an estate plan that's going to work for you. All right, great. Thank you for answering the polls. Everybody is being participatory, and I really appreciate it. So let me ask this question. If you have an estate plan in place, what is it that you're hoping to learn here tonight? And if you don't have an estate plan in place, but one of these things really resonates with you, I hope that you'll flag it so that I can see exactly where your attention is and what you're thinking about. So maybe you're thinking, I did an online will at LegalZoom or wills.com or something like that, or I'm looking at doing an online will, and I just want to know, is this okay? Is this going to take care of my family? And I'll make sure that we talk about that tonight and we cover that. And maybe you wrote an estate plan and it was a long time ago, and maybe you named minor guardians for kids in that estate plan, but you don't have minor kids anymore. All of your kids are grown and they've flown the nest. Now you're wondering, is that estate plan outdated? You know, is my 30-year-old son going to have to go and live with my sister in California if something happens to me? Now, that's obviously not something that has to happen when somebody is above the age of 18. In fact, the kids have a say after they're above the age of 14, but but plans do get outdated. There are changes in the law, there are changes in family circumstances, and there are changes in your assets that can make your plan become outdated. So we'll talk about what those are tonight. And maybe you want to better understand your plan. Maybe you worked with an attorney and they didn't really include you in the process. Or maybe you're looking at writing a plan and you just want to understand, what should I know? What are the questions that I should be asking? And we'll definitely talk in depth about that tonight. You know, whatever reason that you're here, I want you to know that you're in the right place. You are in the right place if you have someone or something that you care about and that you want to make sure that you protect. And you're in the right place if you did an online or fill in the blank will, but you're not sure that it's going to do what you want for your family after you're gone. And you're in the right place if you're nervous about how much this is going to cost. I completely understand that. Again, I am a father of 3 minor kids, 3 very little kids from 9, 7, and 4, and we have one on the way. And so I completely understand sensitivity around cost, and I want to assure you that that I work with people and I make sure to keep things affordable, because I know how important that is in order to make sure that you get an estate plan done and that you get one done at a reasonable rate as well. I'm going to talk about all of these things tonight, and I will make sure that you're very clear on all of them and exactly how to protect the people that you love tonight. Because the reality is, estate planning isn't about us. And this is something that my wife and I talked about when we were recently updating our estate plan. Our estate plan isn't going to enrich us. It's not like a business where we work on it and it's got cash flow into us or anything like that. An estate plan is all about protection. It's all about protecting the people that we love and making sure that they're well cared for when we can't be there to care for them. And your loved ones are going to know whether you lived up to your promise to take care of it and get your affairs in order. And you can get your affairs in order. It's very doable. And we will talk about exactly how to get it done tonight. All right, I promise this is going to be the last poll that I have, but it's kind of a demographics question because I want to talk a little bit about some things that only apply to certain demographics, that only apply to people with young kids, for example. And I want to know how much time I should spend talking to families with young kids or individuals with young kids, and how much time I should devote to other things. And it looks like there are some people with young kids here tonight. Looks like there are a number of people, more people that have grown kids and are joining us tonight. And some people who are married without kids as well. And there's certainly something here for everybody tonight in what we're going to be talking about. So thank you for sharing that information. But here's the types of things that we're going to cover tonight. Again, estate planning and an estate plan is more than just planning for what happens after you die. It includes planning for incapacity before you die. And so if something happens to you and you end up in a coma, or if something happens to you and you start suffering from dementia or Alzheimer's, who can make healthcare decisions for you and who can make financial decisions for you? And what exactly does that look like? And when you do pass away, who's going to take care of the kids? If you have minor children, and I do see some people with young kids here tonight, who's going to take care of those kids? Who has a right to come and stay with the kids immediately? But then who has the legal authority to raise those kids until the age of 18? And if you haven't named somebody, then how is the court going to choose who should be the person to raise those kids until the age of 18? We're also going to be talking about probate. And probate is a court case that we're going to talk about in some depth. But we're going to talk about the time, cost, and public nature of probate, and the fact that a lot of people aren't aware of this, but having a will in place actually means that your estate is still going to have to go through probate. A will does not avoid probate. And you'll hear me say that again in a little bit, but it's really important to know that a will is not enough to avoid that court process of probate. We're going to talk about estate taxes tonight. And there I get to give everybody some good news because the estate tax exemptions in Minnesota and on the federal level are really high. And that means very few people end up being subject to estate taxes. And there is some planning that we can do to make sure that those numbers, those exemptions where you aren't required to pay any estate tax, we can talk about how to make those numbers even higher here tonight and in person at some point in the future if you wish. We'll also talk about unclaimed property and how assets end up in the departments of unclaimed property across the United States. And we'll talk about things, intangible assets, I call them, things like your stories and your values that are so important and that oftentimes you want to share even more than you want to share your tangible assets, things like your bank accounts. Oftentimes it's those values and stories that you really want to make sure continue to the next generation. And we'll talk about how you can share those in an estate plan as well. But before we do that, I want to tell you a little bit more about me and about my family. This is my family. We live in Bloomington, Minnesota. My wife's name is Tobin, and my kids are Ben, Margaret, and Elizabeth. And so that's from right to left. I don't know why I went right to left. So that's Elizabeth on the left is 7 years old. Margaret in the middle is 4, and Ben is 9 years old. And my family is really my whole world. I spend so much time with them and I love them. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day after I commenced from law school, my son, Ben, was born. After law school, I found a job with a small estate planning and tax preparation law firm in Minneapolis. And I love the clients that I was able to work with. But at the same time, I didn't always feel like we were providing the value that I thought that we could to the clients. And so after a little more than 3 years, I ended up leaving the law firm. And this is a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this was not said about me. I have to say that just right off the bat. This was said about somebody that my parents worked with on an estate plan for my grandmother, and they just had a very negative experience working with this estate planning attorney. And I remember in particular, my mom saying, someone has to graduate at the bottom of the class about this attorney. And there's a big reason for that. But I actually don't think it was the attorney's knowledge or ability or intelligence. I think it was the model that this attorney was practicing under, and it's the traditional model of estate planning. I call it kind of a faulty model of estate planning. And I'll talk a little bit more about that later and how you can avoid having a faulty estate planning attorney plan your estate. So I know not everybody has minor kids here tonight. I appreciate everybody for sharing in the polls. Again, you guys have done a great job being participatory. Say that 10 times fast. Again, if you have questions or if you want to add comments to anything, you can feel free to do that with either the Q&A button or in the chat. And I'm making sure to monitor that throughout the night. Again, I know not everybody here has minor kids, but I want to touch on guardianship really briefly because it's so important to people who do have minor kids. So there are 2 types of guardianship that I make sure that all of my clients have, and that's short-term guardianship and long-term guardianship. And short-term guardianship is the situation where mom and dad go out, have a wonderful date night, but for whatever reason, they don't make it home. And the kids are with a babysitter, they're with some family member, and mom and dad just don't come home. And what ends up happening at some point, if there's no plan in place, the police get called and the police come to the house. And the police need to be able to figure out where those kids should go. Legally, where should the kids go? It's a hard thing for police to determine when they're right there in the midst of everything. And so oftentimes what the police will do in order to limit their liability for those kids is to call in Child Protective Services and to put those kids into some kind of Child Protective Service situation or foster situation for a time until somebody else can sort out exactly who should receive the kids. And I don't mean to say anything super negative about Child Protective Services. They do the best that they can, I am sure. But I can tell you, I never want my kids to stay with Child Protective Services, even for a minute. And so it is really important that you get legal documents in place that record who is the person who can legally stay with my kids for a short period of time. They can have that short-term guardianship or that temporary guardianship until the long-term guardians can be contacted and come and pick up the kids. I see here somebody's asking, will this information apply to Texas laws? And principally, I am speaking about Minnesota laws, but I happen to know that Minnesota and Texas share some uniform laws as well. So although I am not licensed in Texas and I'm not specifically speaking about Texas laws in this case, many of the concepts here do generalize between Minnesota and Texas in particular, because a lot of the laws are based on some uniform codes, like the Uniform Probate Code, for example. So again, I'm not licensed in Texas, but that's some information. What is short term? 6 months or less. Short term is more, I would say, about 2 weeks. And so you can imagine if your long-term guardians are, if you're in Minnesota and your long-term guardians are in Minnesota, those long-term guardians can probably pick up the kids within a matter of about a day. They can probably prepare the house, they can prepare themselves and come and pick up the kids within about a day. And so that's the period of short-term guardianship that I'm talking about. But it could also be if the guardians are out of state, if they are down in Texas, for example, or if they're in California, it can be an extended period of time, something like a week or 2 weeks before those long-term guardians can get into place and actually take the kids. And so short-term guardianship can apply anywhere from 30 minutes, who can stay with those kids for 30 minutes, all the way up to 2 weeks to 3 weeks in order to bridge that gap and make sure that the long-term guardians are able to get into a position where they can come and pick up the kids. So long-term guardians, let's talk about that. Short-term guardianship is really that shorter, that more immediate need. Long-term guardianship is who is going to raise the kids until the age of 18. And if there's no plan in place, unfortunately, the state has written a plan for you. And that plan is a judge is going to decide who is the right person to take the kids. And the way that it works, there's a court process called guardianship, and the family comes in and makes the argument for why they are the best person to take the kids. And it can get really ugly, especially if both sides of the family are fighting, or if there are differences of opinion, if siblings don't get along, or whatever the situation is, there can be a lot of conflict over who would be the best long-term guardian to take the kids. And the person who wins might not actually be the person that you would want taking the kids. It might not be the person that you know the kids would flourish with. But you can step in front of all of that by putting into legal documentation exactly who you would want those long-term guardians to be. You can nominate that in a long-term guardianship nomination, which is very effective in front of a judge in letting the judge know exactly what the parents believe the kid would be best for the kids. And judges really rely on that because parents know their kids better than anybody else. All right, so let's talk about assets, and let's talk about how the people that you love are going to receive the assets under the current plan or the state's plan for you. So the state has an estate plan written for you, and if you have planned your estate, but you've planned your estate with a will, then you're also opting into the state's estate plan for you, which is this process called probate. And probate is slow. In Minnesota, it takes a minimum of 6 to 12 months, and more often it takes something like 12 to 18 months. We'd like it to go faster, but the truth is it just can't. It is administratively bogged down. It's just a lot of slowdown. And in part, there's a lot of slowdowns because we want to make sure that creditors get notice of the probate going on and have time to appear and get paid from your estate before the assets go out to the kids or the heirs or whoever is going to receive them. Probate's also very costly. In Minnesota, we estimate that the average cost of an estate is something like 3 to 6% of the gross assets of the estate, or the gross value of the estate. So you can imagine if you own a house that's worth $400,000, and I recognize that that's a pretty nice house, but with real estate prices being what they are, a $400,000 house is certainly attainable by a lot of us. Probate will already probably cost somewhere between $12,000, which is 3% of that $400,000 house. It will already cost something like $12,000 to $24,000 just to get that single property through the probate process. And the reason for it is all of the different parties that are involved. There are attorneys' fees, executors' fees, appraisers' fees, bond premiums, court filing fees, creditors need to get paid. There are all of these different people involved with their hands out trying to get paid through the probate process, making it really expensive, and again, taking a really long time. And we'll actually have a chance to calculate what your probate might cost based on that 3 to 6% estimate for probate here in Minnesota. Probate is also public. So this is the last will of Anna Nicole Smith. And wills are totally public. They have to be submitted to the court and made public to everybody in order to actually work. That's the nature of our court system, is that things are released publicly unless there is some overriding need to make them confidential or to seal those documents. And so wills are put out into the public. The assets that you have at your death, an inventory of those assets is made public, as well as who is going to receive distributions of your assets from your estate is also made public. And we all know that there are predators out there, there are bad people out there who will use this information or may use this information to try and take advantage of unsavvy people who now have access to inheritance money and now have access to more money than they're used to having. It's an unfortunate reality in our world, but it is a reality that the public process of probate is not good. Finally, and worst of all, if you have minor children, those kids are set to receive the assets at age 18 and completely unprotected. And I think we all know stories and we've all heard stories about people who've received assets at too young of an age. Maybe they've received an inheritance, maybe it was something like a lottery or gambling. Maybe it was some kind of investment scheme that just happened to pay off that one time. And whatever the case is, we all know stories about people who received too much money at a young age and it spoiled them, and it spoiled their understanding of finances and financial responsibility. I can tell you, I was a relatively mature 18-year-old, but if I had received a big inheritance, I know exactly what I would have done. I would have gone out and I would have spent it on a Corvette and I would have driven really fast. And that's embarrassing, but it's true that that's exactly what I would have done if I had received a big influx of assets at the age of 18. 18-year-olds just can't handle it. They aren't mature enough to handle it. And so it's really important to protect those assets and make sure that the 18-year-old is protected from the assets as well. So here's our chance to calculate our probate estate with some back of the envelope math. So here you can see some assets that you might find in a normal probate. I have a family home listed or rental property, some furniture and household goods, some automobiles, stocks, bonds, and bank accounts, and business interest as well. All of these items, or none of these items, pass by beneficiary designation. None transfer on death through a pay on death or anything like that. And so all of these things would need to go through probate. You know, the family home, the rental property, if those are owned jointly with your spouse, then they would go to your spouse when the first of you passed away. But after the second of you passed away, if something happened to both of you, then they would need to go through probate before getting to the next generation. And so that's what you can look at. That's when things have to go through that probate court experience. And you can get to 5% of the gross value of your estate in a really simple way. You take the total of your gross estate, you move the comma over one place, so that's 85,000, and then you divide that number in half. And that's how I got to 42,500. That's how you can take 5% of a number really quickly and get to an estimate that's somewhere between the 3 to 6% value of your gross estate. And so you can imagine, you know, these assets are very nice. This person has a very nice estate, but it is not wildly out of control. It is not, you know, Bill Gates level of wealth or anything like that. And you can see that already an estate like this would rack up a lot of probate costs and fees getting it through the system. If you have things that are beneficiary designations or that do have beneficiary designations on them, like life insurance or retirement accounts, but those life insurance proceeds or those retirement accounts are payable to a minor, then the minor cannot receive those assets. And this can happen either if your kids are minors or if something happens to one of your children and they leave grandkids that are minors, and those grandkids are the ones who end up receiving. In that case, those assets have to go through a process called conservatorship, which in a lot of ways is actually more expensive and more time consuming than a probate case is. And so here you can see an adjusted estimate of what a probate might cost if you have minors who are listed as beneficiaries on something like a life insurance or retirement account. Excuse me. I've talked a lot about probate, but the good news is there is a foolproof way to avoid probate. And that foolproof way of avoiding probate is by fully funding a living trust, or a living trust is often called a revocable trust. Revocable trust, living trust, it's the same thing. Sometimes you'll also hear inter vivos trust, created during lifetime while somebody was living. But it's really key that you make sure to fully fund that living trust as well. And so what a trust is essentially is you are giving your property to someone else and you are writing instructions about how they're going to use that property. It so happens that when you're writing a living trust or a revocable trust, the person that you're giving your property to is also yourself. And you are promising as the person receiving those assets to follow the rules in the trust, to follow those instructions that have been written for you, and use the assets that you've just received in the way that the creator of the trust tells you to. And for the beneficiary of the trust, the person who stands to benefit and has the right to benefit, that you are going to use those assets for the beneficiary, which again, in a living trust or a revocable trust, also happens to be you. So you are serving in all three of those roles. You're the creator of the trust, you're the person with control over the assets, you're the person who is controlling the assets, you're also the person who has a right to benefit from the trust, and that benefit from the assets. And that means you can use the assets for whatever you want. If you have a bank account in the name of the trust, you can use that checking account or bank account to go and pay for groceries to feed yourself, no problem. You can use it to pay for groceries to feed someone else. You can give it away to charity. You can use it to buy luxuries. Whatever you want, you are the beneficiary of your trust, and therefore you can use those assets for whatever purpose you have, okay? Fully funding the trust means making sure that assets are no longer titled in your name, but they are now going to be titled in the name of your trust. And so that means for things like investment accounts, going to wherever that brokerage is or wherever that investment account is, and retitling that investment account in the name of the trust. For bank accounts, it means going to the bank and signing new signature cards at the bank so that that bank account is now in the name of the trust. It's been given over to that trustee to control, again, using the provisions based on the instruction manual that you've written, which is that living trust. It means executing deeds to real property so that that real property is going to pass the way that you want it to from the revocable trust to the next beneficiary that you want to have or that you want to hand it off to. And the trustee will make sure that that happens because we write instructions in that trust about how the trustee is supposed to make sure that that subsequent beneficiary receives the assets. Transferring stock and bond certificates, you need to make sure that those also go into the trust. Assigning personal property, and that's one of the simpler things because it's just signing one document that's an assignment of personal property or a bill of sale that puts your assets, your personal property, things like your furniture and clothing, jewelry into the name of the trust. Then changing life insurance and retirement account beneficiary designations so that they are pointed towards the trust and that when they pay out, they go into the trust. So that's how you fully fund a living trust. And that's a little bit of information about a living trust. And I've got to tell you, it works. It really works. It is a foolproof way to avoid probate, but you have to make sure that you are fully funding that trust. It's not just about the instrument. It's about making sure that you have support to fully fund it and that you have somebody watching over and helping to make sure that that trust is getting fully funded in order to completely work. All right, I get to share some good news with everybody. I get to share some news about estate taxes. And right now, the federal estate tax exemption, and that means you don't pay any estate tax until you've used up all of your exemption, until you've exceeded your exemption. The federal estate tax exemption right now is over $12 million. And that means for your first $12,060,000, you pay nothing in estate tax or your estate pays nothing in estate tax when that asset transfers to the next generation or whoever you want it to go to. You actually get to double that number if you're married. And so the number is really $24.12 million that get to pass without any federal estate tax being counted against you. Now, if you are above either of those numbers, you're really going to want to make sure that you do some planning, but I know that applies to almost nobody in the world, and probably very few people that are here tonight. However, Minnesota also has an estate tax. In Minnesota, the estate tax exemption is $3 million. Texas, I don't believe has an estate tax, but again, I'm not licensed in Texas, so don't take my word for that. It is something that if you want to follow up with me, I can figure out. But in Minnesota, we have an estate tax, and that estate tax rate goes from 13% up to 16% on the dollar for everything that is above the exemption amount. And in Minnesota, our exemption amount is lower. The exemption amount is $3 million. And so you start paying on your first dollar over $3 million. And there is a way to double that number for married couples in Minnesota, but you have to do some planning in order to double that number. And it doesn't automatically double in the same way that the federal estate tax exemption does. So again, if this applies to you, it doesn't apply to most people, but if you're worried that it might apply to you, or if it does apply to you, I hope that you'll reach out to me and I can give you some specific information about it. I see somebody asking, does Illinois have an estate tax? How much is it? And yes, Illinois, I believe, does have an estate tax, but I'm sorry, I just don't know the exemption amounts, and I don't know what the rate is in Illinois right now. But I am pretty sure that Illinois is one of the states with an estate tax. And if you reach out to me, I know where to find the information. You can probably Google the information yourself. Illinois estate tax exemption or Illinois estate tax rate, and you can probably find some information on it, but I just don't have it top of mind. Sorry about that. All right, will your assets be lost to the state? Does anyone have any idea how much is currently in our state Department of Unclaimed Property? And that's in the Minnesota Department of Unclaimed Property. The amount is really staggering. It's over $700 million that is being held in the Minnesota Department of Unclaimed Property because nobody's claimed it. Nobody has come up and claimed it. A big part of the way that the money gets there, in fact, let me just tell you, the number across the United States and the various state departments of unclaimed properties is $58 billion. 58 billion with a B dollars. That's so much money. But a big part of the way that the money gets there is somebody passes away and the heirs and the estates and everybody tries to look and tries to find the information about where did mom and dad have their bank accounts? Was it one bank? Was it several banks? Where did they have insurance policies? Was it one insurance agency? Was it many? Where do they have their retirement accounts? Did they remember to roll over all their old 401ks into this new one? Where did they have their investments? Were they trading stocks on any platform that we aren't aware of? Do they have stock certificates sitting in their safe deposit box? You know, there's a lot of money that ends up at the State Department of Unclaimed Property because the kids weren't aware, or the heirs or whoever it is that comes after weren't aware of where all of the assets were. And that's why I make sure with every plan that I write, we do something really important. We create an inventory of your assets, and we go through where are your bank accounts, and we make sure to list out where those bank accounts are and approximate numbers of what is in those bank accounts to make sure that nothing is ever lost to the State Department of Unclaimed Property. We do that with insurance policies and investment accounts. We do that with stocks and bonds. We do that with retirement accounts. We collect all of that information to make it as easy as possible for your family for after you're gone. And that is so important. And I've seen it, how difficult it is to collect everything after mom or dad is gone, and you just don't know. You just don't have the information. Oh, this is really cool. You can make your estate plan a real gift to your kids by giving them asset protection over the inheritance that you give to them. So asset protection means that you can protect their inheritance from things like a spouse in a divorce, or from things like bankruptcy, or a creditor in the future if they're in a car accident or something like that, that you can actually give them protection so that they can use the inheritance for what you want them to use it for. And really that's their enjoyment oftentimes. So this is something that people can't really give to themselves. It can't be generated on a first person basis over our own assets. Some people try, but it's very prohibitively expensive. I'm talking like $20,000, $40,000 to try and create asset protection trust, and it doesn't always work. But you can do it third person by giving your kids money in this asset protection trust that really protects the money from creditors and from bankruptcy, and again, from a divorcing spouse, something like that. It is very cool. It's something that I really like to help my clients with, and that I like to make sure that we do for my clients. Planning for incapacity is so important. And I think a lot of us have felt this, especially recently, the importance of making sure that we have somebody who can advocate for us and who can make healthcare decisions for us. The person that I have pictured here is Terri Schiavo. And many of us remember the case of Terri. Terri suffered a heart incident, and it put her into a vegetative state. And while Terri was in this vegetative state, her family was divided about what should happen to her. Her husband didn't think that Terri would want to live like this and wanted to pull the plug. But her husband, or her parents, thought that Terri would want to fight. And if there was any part of Terri still left in her in this vegetative state, they thought that she would want to fight and would want to be kept alive. And so a number of court battles ensued down in Florida, going all the way up to the Supreme Court about what should happen to Terri and who gets to make this decision. Eventually, her husband won out and the cord was pulled, and Terri did pass away. But all of that court, all of that conflict, it didn't need to happen. And you can not only name a healthcare agent in a healthcare directive, but you can also tell that healthcare agent exactly what your healthcare wishes are and how you want your care, or how you want to be cared for if something should happen to you. And that has to be honored. Your healthcare agent can be a strong advocate for you. That's who I usually recommend. Somebody who understands healthcare, who can be a strong advocate for you, even if you don't completely see eye to eye on what your healthcare wishes would be and what their healthcare wishes would be. Making sure that you have a strong advocate who will make sure that what you want to have happen will happen is invaluable. It's very important. So you're probably asking, after all of the things that we've talked about, after talking about probate and the cost of probate and the amount of time that it takes to get through probate and how it's public, probably wondering, after we've talked about guardianship, and maybe you have minor kids, or maybe you have family members with minor kids, and you're worried about child protective services, or you're worried about the guardianship court battle that might ensue if something happened to you, or if something happened to that person that you love with minor kids. We've talked about incapacity planning. We've talked about who can make healthcare decisions for you and what those healthcare decisions would look like. We've talked about all of the money in the state departments of unclaimed property and how all of that money ended up there. That it was unclear what mom or dad had, and unfortunately that unclarity caused that money to be lost and people to not get to enjoy that money the way that they should. So we've talked about all of these things tonight, and you're probably asking yourself at this point, what can you do today to do the right thing for your family, and what should it cost to plan right? And really your options are, you can either try to do it yourself, or you can work with a lawyer. And keep in mind, not all lawyers are the same. So how do you choose? Should you do it yourself? Should you try and do some kind of online will or Susie Orman will? Or should you work with an estate planning attorney professional who can help you work through it? And I can tell you there are instances where an online estate plan or a Susie Orman estate plan, I think might actually work. And those cases are if you only own things like your personal belongings, your car, clothing, jewelry, furnishings, if you don't own any real estate, if you don't have any major holdings in a bank account or an investment account, if you don't have life insurance proceeds that are going to pay out to somebody, if you don't have retirement account savings, then you might be able to do it yourself. You might be able to take and do that plan yourself. But you would benefit from working with a lawyer if you want to ensure that the people you love stay out of court and out of conflict, and have somebody, a trusted expert, to turn to when something happens to you. And you'd benefit from working with a lawyer if you want a kids protection plan to avoid probate or estate taxes, or to protect your children's inheritance. You really have to work with a lawyer. And the kids protection plan is that long-term guardianship nomination, and it's that short-term guardianship nomination, as well as some documents that bridge the gap and help to plan if something should happen to you and that child needs medical care when you're unavailable, for example. And you really need to work with a lawyer if you want to guarantee that your plan is going to work when your family needs it. And I tell this story, even though it's an embarrassing story. I tell this story about a do-it-yourself project that I did. And that project is I had gotten a new rod and reel for my son and I so that we could go fishing together. And this was almost 2 years ago now. But I was putting fishing line on this new rod and reel, and I was winding it on. And just when I thought that I had everything set perfectly and had strung everything just the way that I thought that it would, that everything would work, all of a sudden that fishing line came jumping off of the reel, and it was everywhere, and it was tangled, and it was a complete mess. Okay. And that was my do-it-yourself project that absolutely bombed. I still don't even know exactly what I did wrong. I think that I probably put too much fishing line on, but I don't know. If anybody puts in chat exactly what mistake I made, because maybe I'm not the only person who's made this mistake. I don't know. But I did this do-it-yourself project where I was putting this fishing line on this rod and reel. And the only loss that I suffered from that was, a couple dozen feet of, or a couple dozen yards of fishing line. It wasn't an expensive mistake that I made. It wasn't a huge cleanup. I just snipped off the line and went and threw everything away. And I still got to go fishing with my son later that day. The other thing, I knew immediately that I had failed with my do-it-yourself project, right? I knew immediately, I got immediate tactile feedback that I had made a huge mistake with the way that I had put that fishing line on that rod and reel. Planning an estate, number one, it's not just some fishing line that you're going to lose. There is a huge cost to getting it wrong with an estate plan. And that huge cost is paid by your family, and it's paid after you're gone. And you're not going to know whether you did it right or wrong. Only your family is going to have to find out later after you're gone and after you can't do anything to clean it up anymore. And so that's why I share that story, because there are things that are good to do it yourself. Put furniture together, put fishing line on a rod and reel. And I don't see anybody sharing. So maybe I'm the only one that this has happened to, and nobody knows exactly why it happened. But there are things where the stakes are really high. And in those instances, it really is valuable to work with a professional who can help you and to make sure that you get it done the right way for your family. And another addendum here, if you want to make sure that your assets go to someone other than your kids, if you have a charity that you want to give them to, or nieces and nephews, or somebody more distant, then it's really important to work with an attorney and make sure that you have that drafted correctly. So what kind of attorney should you work with? Well, I can tell you, not an attorney that people say someone has to graduate at the bottom of the class about, right? But how can you know when you walk in and you talk to an attorney, oftentimes it is so hard to know, is this somebody who's a quality attorney? Is this somebody who understands what they're talking about? Or is this somebody who is going to let my family down the road? And I'm going to help you evaluate that based on my parents' experience and based on what I've seen from other estate planning lawyers and especially that traditional model of estate planning, which I call planning for death. And this is the typical experience that most people who work with a traditional estate planner end up going through. There are form documents that they will plug your name into and a couple of little identifying details, but those form documents are very regimented, they're very set. There's not a lot of customization, and they have a kind of approach where it's a set it and forget it. You just fill in the names and you'll deal with it later on. That's the typical experience. Typical experience is not going to keep money out of the Department of Unclaimed Property. It's just not where most estate planning attorneys put their energy and put their concentration, because most estate planning attorneys think I only have to work on the documents. That's all I have to focus on. But it's not true. There's so much to an estate plan beyond the documents that's outside of the documents. Sorry. But that's the typical experience, is they're going to be very focused on the documents. They're not going to keep your money out of the Minnesota Department of Unclaimed Property. Typical experience may avoid probate, but it might not. Oftentimes, attorneys who practice in estate planning also practice probate. And so if your family ends up needing to come back and go through the probate process, then that's kind of a win-win for the attorney, is they have written a plan for you and been paid, and now they are going to do a probate for your family and get paid. And it's, I don't believe in that. I write plans to avoid probate, and I help and I guide my clients to make sure that that they're going to have a plan that avoids probate. Typical experience probably isn't going to keep the family out of conflict. It's, again, just not something that most attorneys are focused on. They're usually focused on assets only, and not focused on the different dynamics of the family and how that family looks and operates. Typical experience is only going to focus on assets and money. It's not going to focus on your stories and values, those intangible assets that you really want to share with the people that come after you. Typical experience is going to leave assets to heirs unprotected without that asset protection treasure chest that we talked about earlier this evening. It's just not something that most estate planning attorneys focus on or do, that asset protection for the inheritance. Typical experience is not going to include ongoing legal guidance. Again, representation ends when the documents are signed for most typical traditional estate planning lawyers. But that's not enough. That's not where the estate plan actually ends, because the estate plan isn't actually going into effect or effective until you're gone. And so it's really important that you keep that ongoing legal guidance and legal representation. Typical experience is hourly fees for any future needs. And so, they'll send the message very quickly when you get that bill in the mail for a quick 5-minute question that you had. You get the message very quickly, I shouldn't be calling my lawyer because they're just going to charge me more money every time that I pick up the phone. Again, that's the typical traditional experience. And the typical experience is not going to adequately protect kids. Most estate planning lawyers that I know don't do short-term guardianship or temporary guardianship. And they will include long-term guardianship, but only in the will, where you have to actually get that will admitted to probate court before it can be read and before it can be determined whether it's effective or not. So the typical experience is really going to leave you with the same question that you have when you did it yourself. Is this going to work when I need it to work? And that's not a question you should ever have when you work with an estate planning lawyer. That's why I do things in a completely different way. And I call it planning for life. It's a totally different approach. I charge flat fees and I let my clients choose the fee based on some packages that I offer. So it's not just a free will offering, but we will go through some different packages and we'll talk about what it means for your family. And you can choose the fee that makes sense for your budget and that makes sense for your family. Planning with me, it means keeping your money out of the hands of the state. I believe in creating an inventory of my clients' assets so that things are as simple as possible for their family when something happens to them. And so nothing gets lost. And I can tell you that is something that's near and dear to my heart. As somebody, again, with a young family, I want to make sure that my kids receive everything that I have that should be going to them if anything should happen to me. And it's so important to create that inventory and make sure that all of the assets are being handed off. Planning with me, it means protecting your kids totally in the immediate short term, but also in the long term. Planning with me means keeping your family out of court and conflict. I think that is so important. Nobody has to go through the probate process, or very few have to go through the probate process. And it is something to be avoided. It is expensive, it takes a lot of time, and it is rife with conflict in your family, not to mention it is public. And you just don't need that in your family. When your family should have the space to grieve for you, they don't need extra court and conflict in their life. Planning with me means knowing that you've made the right decisions. I am very strong on educating and empowering my clients to make the decisions that are right for their family, that are right for them. And I will guide you along the process so that you completely understand the plan that you are writing and that you're making the decisions and that you're seeing where the hidden questions are that you need to be asking about your plan. Planning with me means protecting family money from outsiders with that asset protection planning, that treasure chest that you can create over your assets. Planning with me means a lifetime of guidance and protection. I'm not going to charge you hourly fees in the future when you pick up the phone and you let me know that your first grandchild or your first great grandchild has been born. I want to know, and it might affect your plan, and we need to talk about that. We need to talk about what it might mean. And I am not going to charge you when you pick up the phone and you tell me, guess what? We just found the house of our dreams. All we have to know is how do we take title to this beautiful house of our dreams to make sure that it goes to our kids when something happens to us. And I'll make sure that you have the answer. And I'm not going to charge you something just for picking up the phone and asking me that simple question. It's just not how I operate. Planning with me means your plan is going to work when your family needs it to work. And it's really a gift that you're giving to the people that you love the most by getting your affairs in order now so that they can have space to grieve when you're gone. And so things can be simple after you're gone. So what should all of this cost? And I want to provide some context here. Again, this planning is going to save your family at least $12,000 if all you have is a house worth $400,000. And that's 3%. $12,000 is 3% of that $400,000 house. More likely, it would cost more. The probate would. But this provides some context about exactly what you can expect your family to have to pay or your estate to have to pay after you're gone. If you have assets over $3 million, then this planning is going to save your family at least 13 cents on the dollar for every dollar in excess of $3 million. That's planning for estate taxes here in the state of Minnesota, where that estate tax exemption is $3 million. I can tell you a typical death plan with a typical traditional estate planning attorney is going to cost a minimum of $1,500. And you can be almost guaranteed it's not going to keep your family out of court or conflict. It's not going to ensure your assets aren't lost to the State Department of Unclaimed Property. And it's only going to cover your money. It's not going to cover your kids' immediate care or your values, your stories or your experiences, your most valuable, intangible, and most often lost assets. Or you can meet with me. I'm a personal family lawyer. I've told you, I do things in a very different way. I help my clients a lot. And you can learn specifically what your family needs and choose your own fee, likely to range somewhere between $2,000 and $8,000, with most people falling about $4,000 or $5,000 for the complete estate plan. And you're going to know that your plan is going to work when your family needs it to work. And I want to make this really easy for you. I want to give you the initial meeting completely free with me. It's a $750 value. It's called the Family Wealth Planning Session, and it's worth $750 because it's 2 hours with me. where I'm going to educate you and empower you to make decisions about your family and about your assets and about the things that you have and how things should go to the people that you love. And just for attending today, and if you commit to do some homework, and if you commit to reserve your family wealth planning session with me, then I'm going to give you this no charge family wealth planning session. I want to give it to you. I want to meet with you. I want you to be able to ask specific questions of me in that private, no obligation initial consultation with me, where you can get your questions answered. And I also want to take $250 off the estate planning fees or the estate planning package of your choice if you reserve your appointment before the end of the week. And I'm actually going to go ahead here and post the link where you can access, I'm going to try to post the link where you can access my calendar online. Let's see, that should work. Let me just click it and make sure that it goes through. Perfect. You can click on family wealth planning session. And I can tell you, unfortunately, you're not going to see a lot of times available. And the reason for that is when I do planning with people, in fact, I don't see anything in March. Well, it's right at the end of March. I don't see anything in April right now. The earliest that I see actually is the end of May and into June, with some pretty good availability in June and some okay availability yet in July. But you're not going to see a lot of times available. And that's because I spend a lot of time with my clients and I work really diligently and with a lot of care and attention for my clients. And that's why you will see there that that there aren't a lot of times, but I just hope that means that you'll be quick to find a time that works for you and get on my calendar so that we can continue this conversation and you can continue the momentum that you've built tonight to get the estate plan done for the people that you love. Again, I want to give you the initial meeting with me for completely free. And I really want to give you that $250 towards the plan of your choice. But you've got to keep moving forward. You've got to keep the momentum. And that's why I sunset it at the end of the week. That's why I sunset it at the end of the day on Saturday, is because this is a momentum thing. And you have probably felt this, right? That it is hard to get the wheels moving to get an estate plan in place. It's hard. And it is hard to keep it moving and to continue going to get it done. But this is the next step. Meeting with an attorney who can walk you through everything, educate you, empower you to get this done. This is your next step. And I can help you with it, and I can help to guide you with it. I see somebody asking, can you give any great lawyers for the Dallas, Fort Worth, Texas area? And yes, I absolutely can. Please reach out to me and please shoot me an email or give me a phone call. You should have access to both. And if if you look at my website, you can certainly find both. Let me post that here. But yeah, please do reach out to me, and I can give you some good contact information for some attorneys in Dallas and in Fort Worth. I'd be very happy to do that. Attorneys who practice in the same way that I do. They're personal family lawyers. They care about clients. They care about serving people. And they make sure that the estate plans that they write actually serve the people that they're writing them for, and really take care of them. So next steps. Again, this is a momentum thing. And now is the moment to take the next step and to get your affairs in order for your family. I know that it's going to be a long time waiting between now and May, or between now and June. But I promise you it's worth it. And we will get this done. Take this next step, get on my calendar, get your homework done ahead of time, and take advantage of the fact that I want to offer you the initial meeting without any obligation. I'm not telling you that you have to come to the meeting with the cash in your hand or anything like that. We can do the meeting completely virtually. I can walk you through and educate you. And if we get to the end of that and you say, you know what, TJ, I actually like the way that the state has things laid out for me. I actually like the fact that my family is going to go through probate. And I like the fact that there are these processes called conservatorship and guardianship that determine who can make healthcare decisions for me and who can make financial decisions for me. If we get to the end of that discussion and you say it's just not worth it, the orange isn't worth the squeeze, you're charging too much, I just can't make this work, then at least I will have the peace of knowing that you have the information, and you will probably rest a little bit easier knowing you've been through it with an estate planning attorney, and now you know exactly what's going to happen. I want to give you that peace of mind. I want to educate you. It's my commitment to the community to be an educator and to help people. And this is the way that I do it, is by helping and educating people. But really, I want to work with you. And I want to write an estate plan for you and with you. And I want to give you $250 towards that estate plan. Again, if you'll just check out my website or my calendar online and get yourself a spot where we can get together and meet. I'm going to go ahead and post that booking link again. And if anybody has any questions, now is a really fantastic time to ask those questions. Again, if you have a question, it's very likely that somebody else on the line right now has the same or a similar question. And so I hope that you will post it in either the chat or in the Q&A where I can see and answer that question. Questions that I often get. What does the family wealth planning session look like? Again, it can be done completely virtually. It's a chance for us to get acquainted with each other and to talk about things in your family and to talk about your assets. And we talk about who would be the person to collect everything for you. Do you have somebody like that? Do you have a responsible child? Do you have a responsible brother or sister? Do you have a parent who might be the person to collect everything for you if something should happen to you? And are they going to be able to find everything? What does that look like? Do you have things laid out in an orderly way? Or do we need to do some work in building an inventory to make sure that they're able to find everything? What would happen if you became incapacitated? Who could make your mortgage payment if you became incapacitated? And what does that look like? And who can make healthcare decisions for you? Who would advocate for you at the hospital? And what decisions would they be making for you? And we would talk about, what does probate look like for you? Again, in Minnesota, probate's a really long process. Oftentimes, it is something like 12 to 18 months. It's possible to get it done in 6 months, but very seldom is it actually done in 6 months. More often, it takes longer. It takes something like 12 to 18 months. It's really expensive. Like I say, it's 3 to 6% of the gross value of your estate is how we estimate it. If all you have is that $400,000 house, even if you owe on that house still, we're talking about your gross estate. So we are calculating that 3 to 6% on the gross value of your house. So we're talking about $12,000 to $24,000 in probate fees that your estate would have to pay. And I can tell you, the estate planning that we've talked about tonight, none of that is approaching $12,000 to $24,000. You're going to save your heirs money by getting an estate plan done and getting it done now. You're also going to save yourself that restless mind, that anxiety about not knowing what's going to happen in the future. We'll talk about, are you going to end up owing estate taxes? And what does that look like? And what does the tax picture look like for your kids around things like retirement accounts, life insurance proceeds? Is that taxable? We'll talk about those things in the family wealth planning session. We'll talk about exactly what that looks like. And we'll talk about how you want the people that you love to receive your assets and what that looks like. And are there special assets that you want certain people to receive? And are there sums that you want going to charity or that you want going to a particular person? We'll talk about all of those things and we'll help you get very clear about them during that virtual family wealth planning session that we do together. I see somebody asking, is the estate plan written per individual or can this be done for both me and my spouse? And that's a very good question. Generally, estate planning is done with the spouse. So it's two people, husband and wife generally do estate planning together. That's typically how it's done, but it can be done separately. And I have had instances where it makes sense to do it separately, especially if most of the assets are held in separate property. or the husband and wife want different things from their estates or from their plan, then it can make sense to do plans separately. But generally, married couples will plan together, and I can help get it done together. Yeah, and I see preference is to be done together, so that's good. Yeah. Other questions that I get, if somebody that you love has special needs, and maybe it is a child, maybe it's a grandchild, it can be really detrimental for that person to receive assets outright from an estate plan or from an inheritance. The reason for that is oftentimes if someone has special needs, they're receiving some kind of government benefit for their healthcare, for where they're living, for their food, something like that. And receiving an inheritance can actually kick them off of that government benefit until they no longer have assets that are above a certain threshold. And so if you have somebody like that in your family, if you want to make sure that they're able to receive something, there is something called a special needs trust or a supplemental needs trust that can hold the assets for that person so that they're able to enjoy those assets, but they're not getting kicked off of whatever government benefit or government program that is helping them, and that is helping them to have a place to live or have food to eat or whatever the situation is. Nursing home care is a big concern for a lot of people, and it's true. Nursing home care is expensive, and it can very quickly deplete an estate. And there are things that we can do to plan for nursing home care. There are things that we can do to plan for nursing home care today, no matter what age you are. Oftentimes it makes sense to look into long-term care insurance, especially if you're younger than the age of 50 or 60. But sometimes that's not an option, and you just need to look at some other options for how to plan for nursing home care. But nursing home care can be done up to and including when somebody is already admitted to the assisted living facility or the nursing home. That's very possible. And so it is never too late to plan for nursing home care expenses, but planning earlier obviously is always preferable. Who can oversee the money? And that's a question that I've had before, that maybe you want multiple people to be able to receive reportings on the money, or maybe you're not exactly sure who would be a good trustee to oversee and take care of the money. Certainly understand that. And that's something that we can talk about and help get clear on when we actually meet and we actually have that family wealth planning session. We can talk about your family. We can talk about professional fiduciaries. We can talk about corporate trustees and different roles that they can take and what that looks like. And we can talk about all of those things in a family wealth planning session and help you to get clear about exactly who would be the best person to take on that kind of role. I'm looking here. I don't see any other questions coming in, but I hope that people will ask them if they have them. Again, if you have a question, it's very likely that somebody else that is here this evening probably has the same or a similar question. And I really want to try and answer any questions that you have that I can before we end here tonight, just so that you feel like you have been heard and that you've had a chance to have your question asked and answered. So I'll wait here just a minute and take a little drink of water. It's been a lot of talking. Hope that you all haven't minded listening. I know it's been a lot of talking here tonight. Oh, that is a great question. The question is, when a plan is written, how often do you revisit it and make adjustments? And that is a really fantastic question. An estate plan is something that is living, and the laws change, your family situation changes, your assets change. So it is really important to have regular revisits of your estate plan and to make changes and to make adjustments as needed. And so in my process, we revisit and we re-examine your estate plan at least every 3 years. And what we do is this free family wealth planning session I offer another free family wealth planning session every 3 years to my clients. And we get back together and we talk about, under your current estate plan, here is what would happen. This is what it would look like if you passed away today. And is that still what you want? Are the people who are receiving under the estate plan as written still the people that you would want to have receive? And are these the assets that you would want going to them? And we would talk about all of that and make sure that everything is exactly as you want it to be. And if there are changes that you want to make, unfortunately, I can't make unlimited changes and amendments without any payment. I don't know what the future holds for you, and you likely don't know what the future holds for you either. And so I just can't offer unlimited changes and amendments, but I can promise you that it'll be reasonable. And I can promise you that we will come to an agreement about what is reasonable and a reasonable way to make those changes so that you can get the changes implemented that you needed based on what has changed in your life or what has changed in the law. So again, that's a really great question. At least every 3 years is when I revisit and review estate plans with my clients. All right. Well, I hope that you have taken advantage. I hope that you have clicked through and taken a look at the times that I have available. Again, I would really love to meet with you. I would really love to help you take the next step and to get an estate plan written. I don't see any other questions coming through, and so I am going to go ahead and call it here. Take a look in your email. You'll see an email come through with my link to my calendar. Feel free to ask any questions there that you have that you weren't able to ask in this session. And if you want to sign up for a 15-minute phone consultation and ask your questions that way, I certainly understand that as well, that maybe you're not ready to commit to the full family wealth planning session. But you'll see on that link that I shared earlier, there is a place where you can get that 15-minute phone consultation. I see a lot of people saying, thanks, great info, thanks for your help, great session. It is my pleasure. I am really glad that you joined me tonight. Your family is going to be really glad that you joined me tonight. I hope that I've given you some peace of mind. I hope that I've empowered you. I hope that I've given you knowledge that will make your rest a little bit easier. You certainly know the next steps to take in order to get an estate plan written for the people that you love. So I'm going to go ahead and sign off here tonight. I hope that you have a great one, and take care.